State of Wisconsin, Circuit Court, Manitowoc County, Branch 1. State of Wisconsin Plaintiff versus Steven Avery, Defendant. Initial appearance, case number 05CF375 and 05CF381. Date November 15th, 2005. Before the Honorable Patrick L. Willis, Circuit Court Judge. Appearances, Ken Kratz, Special Prosecutor. On behalf of the State of Wisconsin, Eric Loy, Attorney at Law, on behalf of the defendant. Craig Johnson, Attorney at Law, on behalf of the defendant. Steven Avery, defendant, appears in person. The court. At this time, the court calls two matters that are scheduled for initial appearance today, both entitled State of Wisconsin versus Steven A. Avery, case number 05CF375 and 05CF381. Will the parties state their appearance for the record, please? Attorney Kratz. Your Honor, the State of Wisconsin appears by Calumet County District Attorney Ken Kratz. I appear in each case as Special Prosecutor. Attorney Loy. Steven Avery appears personally with his attorneys, Eric Loy and Craig Johnson, Your Honor. We would note this is a special appearance subject to objection of the jurisdiction of the court. The court. Has the defendant received a copy of the complaint in each of these matters? Attorney Loy. We have, Your Honor. We just received a signed copy of the complaint in 05CF381. Previously, I obtained a copy of the complaint and the other felony matter in that case. At this time, Mr. Avery is not eligible for our services. We'll be looking into that further, but at this time, he's not eligible for our services in that case. The court. He is not eligible on one case, but he is the other. Attorney Loy. That's correct. The court. What's the basis of that? Attorney Loy. There's an asset. The court. Okay. Are you representing him on that matter for the purposes of today's hearing? Attorney Loy. We aren't allowed to due to the eligibility standards, Your Honor. I guess it's up to the court whether the court wants to appoint counsel to that in that case. The court. To this point, I haven't received an application for an appointment of counsel, and I was not aware until this moment that you would be not representing him on both cases. But a defendant is entitled to be represented by an attorney at all stages of these proceedings. Are you asking me for a continuance on that case? Attorney Loy. Perhaps that case could be continued and the court could hold a status conference on it in the next date on the other case. The court. All right. You have received a copy of the complaint in 05CF381. Attorney Loy. Yes, Your Honor. We'll waive reading of that complaint. Request a preliminary hearing. We're willing to waive time limits on that case. The court. All right. And Mr. Kratz, how much time do you anticipate will be required for the preliminary examination? I would ask for a half a day, Judge. The court. I should indicate for the record, I met briefly with the counsel before we began today concerning their schedules, and it's my understanding that one on Tuesday, December 6th, worked for both parties. Attorney Loy, that works for us, I believe, Your Honor. The court. Very well. The court will schedule a preliminary examination in this matter then for 1 p.m. on Tuesday, December 6th. I do not believe that bail has been set yet. What is the state's request on bail? Attorney Kratz, just prior to talking about bail, Judge, I know that the court has put aside the felon in possession case. Obviously, the evidence which would lead to a potential probable cause finding, the court is similar in that file as well. I don't know if the court is in a position to have a continued initial appearance between now and then, perhaps use that same time as a preliminary hearing date, if and when Mr. Avery is afforded the assistance of counsel. That would certainly be our request, that it be a joint preliminary hearing, and once that decision is made to the court, I'm prepared to be heard on bond. Thank you. The court. Mr. Loy, I'm not sure you mentioned he didn't qualify on 375 because of an asset. Doesn't he have the same asset on the other case? Attorney Loy, the standard for eligibility are different for two types of cases, Your Honor. The court. All right, let's do this. I want to look into the matter on 375 a little further, but I'm going to schedule the preliminary examination at least on 381 for 1 on the 6th, and it may be, depending on my review, that the prelims can be joined between now and then, or may not, because I frankly was not ready for this issue today. Moving on then to the question of bail. Attorney Kratz. Thank you, Judge. Judge, the state is recommending a substantial cash bond in this case. As the court knows, there's a statutory factors that the court needs to consider when deciding the issue of bond, including the gravity of the offense, potential penalties, the degree of violence involved, prior record, if any, character and strength of evidence that is to be presented, whether a defendant has substantial ties to the community. Of those, Mr. Avery, the state agrees, can only claim he has ties to the community and that he does live and work within the community. The rest of the factors are strong indicators of the need of substantial cash bond. The homicide, nature, and mutilation of a corpse speaks to the gravity of offenses within a potential life imprisonment of that Mr. Avery faces includes life plus 22 and a half years. The act is alleged in the complaint, as well as the destruction of evidence, is all highly violent nature. Mr. Avery comes before this court with a prior criminal history, including a 1986 conviction for endangering the safety, in which the case was involving pointing a firearm at a citizen, including a 1980 and 1981 murder conviction, as well as a 1982 conviction for the criminal offense of cruelty to an animal. The state argues that the character and strength of the evidence in this case is substantial, as alleged in the complaint. There's been a DNA match or a series of matches implicating Mr. Avery in the commission of each of these offenses. And for all those reasons, especially given the likelihood that Mr. Avery would flee so as not to be made available for the future appearances, the state is asking for a $1 million cash bond. That's all I have this afternoon. Thank you, Judge. The court. Mr. Loy. Attorney Loy. Your Honor, this case has been investigated for several days, and Mr. Avery was free to come and go as he pleased. Despite the fact that Mr. Avery knew about this investigation, knew that he was a suspect, he didn't go anywhere. He has substantial ties to the community, numerous family members, a number of them are here in the court today. The convictions that Mr. Kratz mentioned are all cases that are quite old. I would ask the court, if the court is going to set a cash bail on this case, to set a more reasonable amount that perhaps Mr. Avery and his family might have some hope of posting, perhaps in the neighborhood of $50,000. Thank you. The court. All right. As counsel points out, there are factors the court is to consider that cut both ways in this case. I think that Mr. Avery has ties to the community that has not indicated, or that's been no indication that he is inclined to flee. On the other hand, he does have a prior criminal record, as the state points out. At this early proceeding, there are some indications in the complaint of corroborating elements to the evidence, but I think the primary factor here is the severity of the offenses that are charged in the terms of warranting a significant cash bail. So the court is going to set the cash bail in this case at $500,000. Is there anything further from either party this afternoon? Attorney Kratz. Judge, is there an opportunity that the court would like to discuss on the 375 case, or perhaps in a phone conference or something along those lines? My concern, and I appreciate the court's dilemma, my concern is that especially the victim's family doesn't have to go through the prelims process twice. The court. All right. How about a telephone status conference this coming Monday at 4? Attorney Loy. It's possible I will be involved in a trial then, Your Honor, although it's doubtful. The court. Let's do this. We'll tentatively set it for 4. It's only going to be a status conference. The defendant need not be present. We won't be going on the record. If for some reason, Mr. Loy, you're in trial and unavailable, let my judicial assistant know and we'll arrange for a different time. Attorney Kratz, that's fine. That's the 21st judge? The court, that's correct. Attorney Kratz, who should initiate that call? I'm happy to do it, Judge, if you want me to do it. The court, that will be fine. Attorney Loy, I will probably just come over to your chambers. The court, anything else this afternoon? Attorney Kratz, that's all for today. Thank you, Judge. The court, at this time, the bail is set to cover for both files. I will make the bail decision this time, even though initial appearance is continued on case 375. If there's nothing further, we're adjourned for today. Proceedings closed.